It's sort of the difference between a shotgun and a rifle. Use your strongest argument, develop your strongest argument. If you have other arguments that the client is insisting on you making, it might diminish the effectiveness of the one or two that may be really important. I'm Joan Kessler. I'm a judge on the 1st District Court of Appeals, which covers Milwaukee County, period.
I'm Sherman, and I'm on the 4th District Court of Appeals, which sits in Madison and covers 23 counties in the southwestern part of the state. The focus of the presentation today was to inform the lawyers in the audience how they can most effectively make their case on behalf of their clients to the Court of Appeals. The most important thing to me is that people's arguments be logical and clear, and that they use short sentences, short paragraphs, and that the logic of what they're trying to say follows clearly from sentence to sentence and doesn't just jump all over the page.
I think in the argument part of the brief, it is really important to be scrupulous about the accuracy of the cases that you're citing. And if they don't actually say quite what you want them to say, that's when you should explain what the difference is so that we don't get the feeling that we're being misled. I think it is really important, most important of all, is for the lawyers to decide from the beginning what arguments are really important and persuasive and have an opportunity to win. It's almost never that a large number of issues are so badly mishandled by the trial judge that each of them is going to be a basis for reversal. And the quantity will diminish the impact of the ones with the quality.
The lawyer's job in an appeal, just like a lawyer's job in a courtroom, is to effectively advocate on behalf of their client. Only in the Court of Appeals, they're primarily advocating in writing. And so it's very important that the written materials, called briefs, that the lawyers submit are going to effectively make their argument. Every time they do something that makes it harder for the judge to understand what they're trying to say, they're erecting a barrier against their own advocacy. They're working against their own client, to put it bluntly, when they do things in the brief that make it very hard for us to understand what they're trying to say.
The lawyers who don't include the specific order appealed from and the trial court's explanation on the record, if there was one, of the reasons for the order are not doing an appropriate job for their client. By the same token, the lawyers who include pretty much the entire record in the appendix are not really helping us. In the civil cases, the thing that is most often a difficulty is a contract or something of that nature is the focus of the dispute. And it's nearly impossible to find, even if it is in the appendix, because it's not set out as the first thing like this is the insurance contract. Instead, it is attached as an exhibit, otherwise unidentified, to somebody's affidavit presenting a bunch of documents for summary judgment. That makes it sort of a scavenger hunt going through the appendix to try to find the document that really matters, that you know has to be there, because that's what the whole fight's about.
I think one thing that a lawyer can do better is to keep the preliminary matters. That is, at the beginning of a brief, you recite the history of the case, you recite the facts of the case, and you recite the issues that are presented. You need to do that clearly and succinctly, and to keep that part of the brief, if you will, brief, so that the focus of what the judge is going to deal with is in the argument. You want to use the preliminary matters to familiarize the judge with what's to come. But what's to come is really what counts.